The tenant's insurance requirements, contents coverage, you want to make sure that the replacement value of the property is covered. I also make sure that the tenant gets liability insurance. You always hear the raging keg party where the drunk guy falls down the steps. You want to make sure there's adequate insurance there to cover something like that. Landlord's bankruptcy, what happens if the landlord files bankruptcy during the term of the lease? I always write into the lease that, or the lease agreement, lease purchase, that the landlord has to refund that deposit fee. The problem with that is, and I'm not a bankruptcy attorney, is the way I understand it, is that there is, I didn't hit anything. I went blue screen. I don't know if it went to sleep or not. Right. Computers. Hey, power went down. No problem. Yeah, I can keep going. I'm good. Okay. Well, anyway, with the bankruptcy thing, one of the way I understand it is that depending on the chapter that the person's filing under, in Chapter 7, there's going to be a trustee involved, and the trustee's guy's going to say, he's the one that's going to dictate whether or not that money can go out. So if you're looking for your deposit fee back and you're trying to get it from a trustee, it's their decision. So it might be really, really difficult to get that back. Just another risk involved. Keep going.
Right.
Yes.
The tenant's insurance requirements, go back over that again, liability and.
Sure. Contract coverage. Just, renter's policy. Correct. Regular renter's policy with liability. Correct. All right, back on track here. There we go. All right, so what happens if the landlord's foreclosed upon? Well, that's no good. The tenant's pretty much out of luck. All those rental payments already made are probably going to be gone. Recovery of that deposit fee is going to be difficult because if the guy is not making his mortgage payment, that money is probably not there. Again, probably have to sue in small claims court for money owed. It's just one of the major risks that the buyer is going to take if they're going to do a lease purchase. Let's see here. I don't know if I have. Looking at that one, I added another thing here. Repairs during the term, because I thought about this. This is really important and can be dangerous and good at the same time. So like I said, the sellers don't want to be a landlord. So what they want is they want to say, hey buyer, here's the house, you're buying this in 2 years. You make all the repairs. This is after the inspections and repair negotiations that happen up front with that pursuant to the terms of the offer and purchase. So, sellers out there saying, go ahead, buyer, make all the repairs, you're responsible for them. And, I've had cases where the buyer wants to put a deck on, because they're at the end of the day, they're going to buy this house in their mind. So, the dangerous part about this is that you want to make sure if you're representing the seller, that the seller is going to have some sort of say in what's going on. Because the last thing you want is for the buyer to do shoddy repairs, make the property in a worse condition than it was, the deal falls apart, and now your seller who's going to put the house back on the market has to redo a roof or something. So the way I draft it is I usually say that the tenant's responsible for all repairs. Any repairs over $50 have to have the prior written consent of the landlord. So at least the landlord knows what's going on if it's a major repair. And they can say, you know what, I don't want you to do that, or that's fine, go ahead, here you go, I'll sign it. It's just a little CYA for you guys, for me, and it makes sure that it makes the seller aware of what's going on inside the house. I've got some additional concerns here that I added. One of them is filing a memorandum of lease. A memorandum of lease is something that's put on the public record that says that this property is under contract and a lease purchase. And what that does, it protects your buyer from the seller. If the market takes an uptick, it protects your buyer from the seller going out and going under contract with someone else for a higher price, going to another attorney's office and closing it. Because when they run a title search, this memorandum of lease is going to be pulled up, and they're going to say, no, this deal's done. You're already under contract with this guy to buy this house. So why do a lease purchase? They sound pretty awful, right? There are some pros. I know it's hard to believe, but the one pro is the seller gets some income to offset his mortgage payments. Usually the seller's holding an empty house here and wants to get somebody in there. It's been on the market for a while. I mentioned it before, any improvements made by the tenant are going to remain on that property. So the tenant builds that awesome deck in the backyard and the deal falls apart. Guess what? Your seller's now got a great deck and can relist that property, and that'll be on there. It also it gives the tenant it gives them time to figure out their financial issues if that's what's preventing them in the first place from getting this loan to do a straight purchase. Also, a tenant in these situations is much more likely to keep the property in good repair than a regular tenant, because at the end of the day, they're going to be buying the property. So why would they trash the property they're going to buy? And that's a good thing for the seller. The cons, there's just so much more time for things to go wrong. I compare a lease purchase to food in the refrigerator. It's great up front, right when it goes in. The longer it sits there, the worse it gets. A 2 or 3 year lease term, there's just so much time for things to go wrong, and inevitably they do. The housing market also might change. So you've got a seller who's under contract now to sell a property for $250,000. The market goes up in 3 years. It's a 3-year lease or something like that, and now he can get $300,000 for it. Well, he's stuck selling this property at $250,000. Also, I mentioned it before, the seller is going to be a landlord for a period of time, and sellers don't want to be a landlord. So, and they're going to have all the responsibilities of being a landlord. One more thing that I just kind of added this the other night, there might be liens put against the property during the time of the lease. So, do a title search up front, see what you're dealing with the seller. If you're representing the buyer, call me, I'll run a title search. There might not be anything on the title, which is great, but let's say seller doesn't pay his federal income tax. Then you've got a $15,000 federal income tax lien, and when closing comes up and we run another title search and the seller, let's say, was going to be cutting close anyway, either bringing money to closing or barely making a little bit of money, now has to bring $15,000 to closing, and he can't. What if he doesn't have the money? Well, the deal's done. I mean, he's breached the offer to purchase and contract, the buyer gets his earnest money back. But what happens to all those rental payments? What happens to the deposit that was already put down? It's gone. That's just one of the risks that you've got to take. You've got to be willing to take, and you need to advise your clients on before going into these. There's also a due on sale clause in every single deed of trust. So if you represent the seller, what a due on sale clause says is any transfer of ownership, the lender has the right to call the note due in full. The seller might want to discuss this with his lender to see if that's actually going to trigger that. Usually it doesn't, but it's worth a call. All right, so in conclusion, what I want to stress again is that these things are not simple. These are not simple transactions, as you probably already know if you've already been through a couple of these. They're very tricky. They have a very, very low closing rate. There are a ton of risk involved for everybody, including you guys and myself, because when things go wrong, you're the first call, and then I'm usually the second. So we want to be careful. We want to work as a team here.